Welcome to episode 49 of 5 Reasons Not to Harm Your Loved Ones During Quarantine. I have great news for you. Guess where I am today? This is my office. Just here for a couple of hours, moving some stuff back in. We just had it cleaned and disinfected, and we're super excited to be starting in a fresh new space that's germ-free with all our policies and procedures in place. And so with that, let's get moving. We have a lot of material to cover today. The first COVID update, as you know, we didn't have one yesterday. So this is kind of a 2-day, but we're going to do it really quick because, as I said, we have a lot to talk about today. So there are 58,999 cases in Michigan. It's up 129 in 24 hours. The big rise is because of some counties that are in the, I'll call it the mid-northern west side of Michigan, like north of Grand Rapids, but south of Cadillac. They are a phase behind the rest of the state in reopening because of their increase in cases. And some rumor that in one particular county that they have hundreds of cases, where in others they've had like 12. And so in the interest of protecting everyone, that whole region has had to stay back until they flatten their curve a little more. And as I said, rumor has it that when this originally began, because there weren't any live cases there, they were not taking measures to be safe. And they weren't social distancing, they weren't wearing masks, and so here they find themselves. And now that lower southeastern Michigan has gotten to a good place, I hope those people just stay up there. Anyway, as of today, of the 58,999 cases, 42,041 of them have been asymptomatic for more than 30 days and are considered recovered. As we've talked about before, people may test positive even if they've been symptom-free for 30 days. There's different kinds of tests. Go back to other episodes to hear about them, or you can certainly read about the different kinds of tests being used now on the coronavirus michigan.gov page, which is just full of statistics. It's fascinating. I love going there every day, and then I fact check with other resources and the CDC to make sure that I'm giving you accurate information. Other things that are happening as of, oh, you're very welcome, Ms. Fox. On June 5th, the Michigan Department of Health and Human Services COVID-19 stats are now on their website. They provided additional services, 50,000 additional families effective June 5th. That food will be provided through the end of June 2020. And the Michigan National Guard has now set up 6 new testing sites around Michigan. So again, the efforts continue to help people and to help people recover. As of June 3rd, the governor appointed a task force called the School Advisory Council that contains educators, parents, and students who were appointed. On June 3rd, also the visitation rules in hospitals were relaxed a bit. If you recall, originally, even if it was a child, if you brought them to the hospital, no parents could come in, and they were immediately isolated. It was very detrimental to a lot of parents and definitely stressful for their children. Also, that went across the board with the elderly. So that's really nice that they're feeling optimistic that both our medical system can handle additional cases, and that the hospital can now treat other people other than COVID-19 patients. So definitely moving in the right direction. Only other update on the COVID front is that as of June 2nd, all COVID testing is being paid for by insurance. And if you don't have insurance, it will be paid for through Medicaid or Medicare or from the state. So no one should hesitate in getting tested if you are concerned if they have not been able to before because of cost. You don't have to have requisite symptoms or anything to get a test anymore. So now on to our topic of the day. As I mentioned yesterday, and for those of you who missed yesterday, it was all about should I stay or should I go, different things to think about, how to be prepared if you're going to leave, how to feel more confident, how to have a plan, or if you're afraid that your spouse might leave. We didn't really talk about that very much. So I'm going to spend 2 seconds right now talking about that, and then we'll go into kind of what it's like to first go and consult with an attorney, and then kind of what the beginning of a divorce case looks like once it's in court. So if you suspect that your spouse is going to leave, there's a couple of things that you want to make sure, and it's kind of a flip of the checklist we talked about yesterday, but you want to make sure that you have you have access or copies, or you've already taken the electronic copies of the electronic documents and saved them in your own electronic file, Dropbox, the cloud, wherever it may be. But you want to make sure that if you think your spouse is going to leave, that they can't take all the information. The one, if I could tell you anything that is like the most important thing, it's that you have access to the records, so that you have access to know what you have, what was there, what should be there. And so those are definitely things that you need to be conscious of and aware of, and go video, go open every drawer, open every closet, take pictures. And even if you're not the one leaving, you want to make sure that they don't go grab all your jewelry and run out of the house, or grab that $1 million baseball card collection and run out of the house. So those are just some things to think about if you're afraid that your spouse is going to leave. You also want to make sure that you have access to money. So whether it's opening your own bank account and depositing a portion of money in there, kind of as a savings for a rainy day. Something that a lot of my clients do, and they thought of this, I cannot take credit for it at all, is they will go and buy gift cards, like at Kroger. They'll buy like Visa gift cards, or just in small amounts at a time or bigger amounts at a time, whatever, and then they have that financial device to help them if they need it in an emergency, or if they find their bank accounts are cleaned out. So let's move on to what to expect if you are looking to have a lawyer assist you. We've done full episodes of this on how to pick a lawyer, how to find a lawyer who's the right lawyer. So I'm not going to go into all of that unless one of you puts that question up there right now. But basically, you have to sleep at night. This is a very, very emotional process. The most peaceful, people getting along, amazing ability, the people who can co-parent, the people who totally agree that they should be divorced, agree, they've already divided the property, it still sucks. It's still challenging. There's a lot of emotional elements to it that people don't expect. So part of the decision-making process and to make which lawyer to hire, as well as when to hire them, what to do, it all really is individual. I will not represent both people. Some lawyers will. I think that even if they're totally getting along at the beginning, there are emotional chords that will be struck, and there will be times when they're not getting along, and I don't want to be in the middle of that. It's ethically compromising, and that's not something I would ever do. The other thing that a lot of people will come in and they'll be like, neither one of us wants a lawyer. We drafted this judgment of divorce. Can we just hire you to look at the judgment and help us prepare the final forms? We will do that because everything has been agreed before they get here. We make them sign a waiver indicating that we didn't give them any legal advice about the judgment, about the terms, about the division of property. And that we are simply processing the information that they've provided, and that they are responsible if anything is not in accord with what their intentions were. We do the record for divorce and the other forms that need to be filed, an income withholding order or uniform support order, in that situation, just to help them get it all done. So that's a different circumstance. But in our ordinary life, we have, one spouse or the other coming in. They usually are not absolutely sure they want to get divorced. They want information. So our first meeting is really about the process and about preparing to file. Sometimes we make referrals to counseling for an individual therapist as opposed to if they've been to marriage therapy. I think that it's very empowering to people, gives them an outlet for emotional energy that you don't want them throwing if they're about to be ex-spouse, or certainly not if they're children. And so those are some of the things that we talk about at the initial meeting. We give people what we call our family law client questionnaire. Sometimes, and we try to send them this in an email before they come in, or we ask them to come in 15 minutes ahead of time to start filling it out. The reason we do that is it's really lengthy, and some of it you're going to have to look up the information. You're not going to know off the top of your head. We don't expect the whole thing to be filled out and perfect when it's given to us. Some people come in and we do it with them, from the get-go. So basically, it asks information about both our client and the spouse, or about our former spouse, and it's personal information. It's name, birthday, age, where you were born, where they were born, driver's license numbers, social security numbers. If they were in the military, we have to have their armed forces status. If they're presently in the military, the procedure for divorce is different than if they're former military. So those are things we want to know up front, so that we're definitely talking to the person about relevant information for their situation. We also, very, very, very important part of the meeting is to determine who we're allowed to talk to about the situation. Often we see people come in with their mother, or a sister, or a best friend. The confidential relationship is between the attorney and the client. If there's a third person present in the room, or a third party who is getting information, then that information is no longer privileged and confidential. So that is very important, and every lawyer should be asking that about every single kind of case. Other things that we need to know initially are where the marriage took place, the date of the marriage, and the date of separation. If you're still living in the same house and there isn't a formal date of separation, that's fine. If there is a date of separation that's like officially like, I moved out on or he moved out on, then that's great too. If there's a date of separation that's not quite so fine line, like one of the spouses got arrested for domestic violence and never returned to the home, then we use that date as the day. In order for a court to have jurisdiction, the person has to have lived in Michigan for 180 days, so 6 months, and they have to have lived in the county where you're going to file for more than 10 days. So that's all really important. You have to know the names of the parties before the marriage, and we have to know if one of the parties changed their name, if they wish to change it back or to change it to something else. Those are all things that will be contemplated both in the complaint when we file and in the judgment. If you are aware, if your spouse has already consulted with an attorney, that's often helpful. There's all kinds of schools of thought. If it's important to file first, it's important to be the plaintiff. I think all in all, at the end, it doesn't matter. It's certainly, if there are kids involved, then I guess the predominant school of thought is that you want to file first, because then you can ask the court to enter what we call ex parte orders. It's an order that's entered by the court that allows it will grant custody to one party, the other, or jointly, and it will establish a parenting time schedule. Another ex parte order that can affect children would be, it could be a vacation schedule. It could be, and we could ask the court to refrain the other person from removing the kids from the state of Michigan or removing them from the country. There's all different provisions that deal with kids, that sometimes it's urgent and we can't wait 7 days for that order because there's a risk of something either physically, emotionally, or just an uncompromised situation, that needs to be taken care of, and they can't wait for the actual hearing date. We also want to know, the other reason that we do ex parte orders is to protect the assets. From the day that it's filed, both parties will be restrained from selling, disposing, transferring ownership, any asset, if we file that type of protection order. We also ask for a status quo order at that point. And that means that the party that was paying the electric bill still pays the electric bill. The person paying the mortgage still pays the mortgage. You can't cancel any insurances. You can't change the beneficiaries on anything until the court allows that to happen. So those are just 3 types of ex parte relief that can be sought at the time a divorce is filed. We don't do it in every case. There's reasons to do it, reasons to not do it. If the spouse already has an attorney, we just try to get them to agree to mutual orders, and we try to save our clients money that way. Other things that we need to know in the initial meeting are whether or not there was a prenuptial agreement, or whether or not they're going to need some kind of if they have a postnuptial agreement or need one. We also need to know the date of birth, the age, the social security number, the schools, the grade, and who each child is living with. We need to know where the children have lived for the last 5 years. We need to know if there's any chance that mom is pregnant. It's not pregnant with about to be former spouse's baby. It's pregnant, period. There is a presumption in Michigan that if you're married and you're pregnant, it's your spouse's baby. We have to take different procedures in order to name someone else the father and to declare paternity with someone else. So we handle it differently. We'll need the health care for the children as well. as if either spouse is paying child support on a different child that's not from this marriage. We need to go through and explain how custody is decided. It's based on the 13 best interest factors, and what happens in my office is when you come in for your initial meeting, you have your questionnaire, you'll get an explanation of the best interest factors. We'll ask you as homework to basically look at each factor and write down how you would win that factor. So everything good about you, everything not as good if that's the case, or some factors are equal about your spouse. And if you really want to be an overachiever, you can put in there how we're going to prove it. And it could be, one of the factors, for example, is the parent who helps with the homework and who the child looks to for guidance. So it would be really great. You can prove it with a report card and a parent-teacher conference note. So it's things like that. And then there's things that are more in-depth than that as well. Children can have a preference if they're over 13. However, that factor is only one of 13 factors. It doesn't get any more or less weight than any other factor. I think that the court looks at the older children, 16, 17, more deference is probably given to their preferences because they're not going to participate in the parenting time if it's not what they want. I'm not saying that they are allowed to control the parenting time, but they certainly will have wider parameters and a lot more choices available to them. So we'll also talk about, if you and your spouse have had discussions related to what the custody arrangement is going to look like or what the parenting time arrangement is going to look like, then we want to know that up front. There's no reason for us to guess and try to get orders and file most motions if you've already figured it out. It may need to be tweaked. A lot of times people don't think of some of the intricacies. For example, this was one that we just experienced. No one contemplated having summer parenting time begins on the last day of school. So was the last day of school March 13th when school closed for the rest of the year, or was the last day of school today, actually, which would have been the real last day of school? So, it's things like that we would never contemplate because we've never been there before that have also come into play and we can talk about up front. A lot of times people say, that their child is a travel hockey player. Well, if your child's a travel hockey player, then child support alone isn't going to cut it. We have to make sure that not just the ice bill is paid, but the hotel is paid, the transportation is paid. We're going to have to divide the tournaments. Who's taking the child? What's going to happen to the other children if there's other children? So a lot of that first meeting is, let's just look at the circumstances and let's think about it. Let's have some goals. Let's be on track. We don't want to wing it through litigation. That would be outrageously expensive. The other thing that we do talk about in the first meeting is fees and how to keep your fees down, how to keep control of the issues in your case, what things you should be talking about if you can with your spouse, kind of reasonable ways to talk about them. We try to use the win-win model in my office. What is the most important thing to you? What is the most important thing to you? How can we make both of you happy? And sometimes that takes being really, really creative. Sometimes in that situation, the parent will say to me, I just want to make sure I have every single Christmas Eve. I don't care about the rest of it. Okay, well, that's a pretty powerful, bargaining tool. So then, I can go to the other attorney or I can make a proposal where I can do a proposal for, the not client yet to have a discussion before it's a full-blown adversarial proceeding about, with different options, and force them both before they've even filed to think about how they're going to accomplish their goals. So that's something really, really important to, it can be discussed ahead of time if you are speaking. Also, it's helpful to make, and we talked a lot about this yesterday, make a budget. How much does it cost for you to live? How much does it cost for your kids to live? How much does it cost to run your household? The more you know about that, the more planning we can do in advance. The other thing you want to make sure that you tell the attorney is if you've ever filed for divorce before. And if you have, do you have those pleadings? How long ago was it? It's worthwhile usually to, if you don't have those pleadings, you can go online, you can buy them and have them emailed to yourself. They don't have to be certified or official. They're just, there's a lot of information in them that we can get very quickly by obtaining those prior pleadings. Another thing we need to talk about at the initial meeting is whether or not anyone else is going to claim custody of the child other than the parents. Are there grandparents who think that the parents are, all drugged up and not able to parent? Is there a guardian, or has there ever been a guardian for the child? And if the child has been in a guardianship for more than 2 years, then that guardian is in a position to file for adoption. And that would be a competitive custody situation that needs to be disclosed and known about in advance. You also want to be prepared to talk about, I'll call it the kind of the dirty dozen. Is one spouse being unfaithful? Does one or both spouses have substance abuse issues? Are there alcohol issues? Is there are there mental health issues? Is anyone in treatment or been in treatment, either for mental health or substance abuse issues? Is it anticipated that either spouse will claim abuse? Is it anticipated that either spouse will say that they forfeited their own career to work and fund the education and career of the spouse? All of these things come into play. If the person has left and they're in a shelter, or they're in a situation where there's an accompanying or related criminal case, we have to handle that differently. We need to have police reports. We need to have interviews of the children if they were done by video. So again, what we're going to do later on in the process is all dependent on what we know. So that's why this questionnaire is so important, because it forces you to have to think about those things. We also talk about employment and employment history. We talk about distinguishing scars, tattoos, or marks on either one. We talk about, we need pay stubs, we need statements from pensions, and we're not expecting anyone to have this at the initial meeting. It's just, things we're going to talk about, and, if they exist. Real property, how many homes, if any homes, does the person own? How many cars, do they own them, or are they leased? Who's paying the insurance? When were they purchased? Is there equity? These are the kinds of the questions that you're going to be asked. You're going to be asked about every bank account, credit union account, brokerage or investment account. What you own. Have those statements if you can. It's much easier if you have statements than if you guess. Also, retirement plans, pensions, KIOs, 401 plans, IRAs, profit sharing plans, stock bonus or option plans. We need to know about that. If one of you works for the government, one of you is in the military, or one of you works in education, you have different qualified retirement plans than businesses do. So those have to be handled differently. And so if we know this up front, then we're not trying to value and divide as if it was a business and the way that that would be done. We have the right consultant involved from the very beginning to value the plan and to assist us in making sure our judgment comports with what the plan requires in order to give the non-owner spouse their share. The share is determined from, it's the amount of increase or profit from, or growth from the date of the marriage through the judgment of divorce, unless it's decided to be a different day. A lot of times, people don't want to break open their retirement account to satisfy the property obligation. So instead, they'll do a trade-off. Maybe, I keep my whole retirement and you get the house and all the equity. That's kind of common. Or you get the vacation house and I keep my retirement. Things like that. Other things that are of value in a divorce that a lot of people don't think about are patents, inventions, copyrights, life insurance, annuities, even term insurance through an employer. That would still be counted, and we need to know it exists. If you don't know the answers, though, we have a discovery process, and we're going to ask them to take an oath and tell us what their assets are. We now have a new form that's required to be filed as of January 1st, 2020. It's a financial disclosure form that is required by the state of Michigan to be filed and identifies all the assets, and you're supposed to affirm that that's true. So we don't have to dig as far to find them. They should be disclosed up front on that form. Another thing of value are business interests. If someone is a partner, either a silent partner or an equity partner or a non-equity partner in a business or a venture, that is marital property. If they came into that relationship during the marriage, or if they were in it prior to the marriage and continued through the marriage. Other things that need to be identified are if you are a family that has ever lived in a community property state. The community property states are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. And we need to know the status of the assets when they were brought into Michigan. Whose were they? Were you already married? Were you not already married? How did they come to be? Did the person who owns them purchase them? Was it a gift? Was it an inheritance? So all those things. If you've lived in one of those states, I can tell you right now your divorce is going to be more expensive because it's just a lot of work to figure that out. Again, if people were in the military, if there's retirement accounts from the military, the pension, etc., they're handled through different tools to distribute them and to value them than other retirement benefits. They're dependent on the rank and pay grade, as well as on the discharge date status. If their status currently, if they're not discharged, if they're reserve, active, retired, honorably or dishonorably discharged. Other things: jewelry, artwork, antiques, coins, stamps, anything that was inherited, electronics, computers, sporting goods, firearms. Are there safety deposit boxes? Is there a safe in the house? What's in it? All that stuff. And then you have to go through and know all the debt. So who is owed? If it's a person, are they related to either spouse, or are they or is it a bank? Or is it just a loan company, a mortgage company? Have there been any substantial gifts that have been made by either spouse to someone else? Has any property been taken out of a joint name and put into an individual name? If there's a trust, who are the beneficiaries? What are the conditions that give access of that trust? That's important. And then, of course, a list of things that are premarital assets, things that you owned before you got married, things your spouse owned before you got married. The ugly green chair that you've had to look at because it was his favorite for years and years and years, he can have it back. And then if you're aware of any assets that have been given away, sold or hidden, or if you suspect, people are not really good in the electronic age of hiding money. They think they are, but there are a lot of great resources out there and tools that help us to discover hidden assets. Again, as far as liabilities, credit cards, if there are liens on the house in addition to having credit cards, if there's tax liability, either federal, state, or local, that also needs to be discussed. And then the status quo type stuff. Who's going to live in the home? Where are the children going to live if there are children? Who's going to pay the utilities? Who's going to pay the insurance? Who's going to make the car payment? Who's going to pay for the cable? Who's going to pay for the private school? If there's private school, who's going to pay for camp? Who's going to pay for extracurricular activities? Those are all discussions I highly, highly recommend that people have before they actually file, so that it is a more peaceful discussion. The other issue that is never a peaceful discussion, no matter when you have it, but I think it's beneficial to at least drop the bomb before you file, is about spousal support. There's a formula that we use to determine if a particular family is a case that's eligible for spousal support, but and it is dependent on the length of the marriage and the income of the parties, as well as some other factors. But usually kind of the rule of thumb is if you have one spouse that's the wage earner, one spouse that's been stay at home, the amount they're going to pay is basically a third of their income for a third amount of years that's a third of the marriage. That's kind of the unwritten rule of thumb, one we guess. But not all cases, even when the one spouse was stay at home, are eligible for spousal support. It depends why the person isn't working, especially if the kids are in school all day. So that is that's basically what's going to happen in the initial meeting, other than the whole procedure will be explained. So we're going to go through the procedure right now, and then we will tune in tomorrow for episode 3 of the 3-part series, and we'll go through the grounds for divorce and the actual what kinds of things you do if you're the filer, what kind of things you do if you are not the spouse who filed, and we'll talk about that tomorrow. But just finally here, the pretrial procedure, or what happens. So we draft a complaint. It doesn't have every single fact in it. A complaint starts a lawsuit. The divorce is a lawsuit. There are different kinds of coding that we use when we file divorces. We code the case with if there are minor children involved, if there are not minor children involved, if it's a paternity action, if it's just a support action, if it's just a custody action, or if it's some kind of matter like a legal separation already exists and we're converting it, then we have a different code. So a lot of those preliminary questions help us to know what kind of code the case needs to have on it when we file. When we file, there is a fee. A divorce with children is $375. The complaint will basically spell out the reasons that, not with specifics, but why there is a breakdown in the marital relationship so that the bonds of matrimony have been irreconcilably broken. That is the standard to get divorced in Michigan, and so that is what our complaint must allege. It will include that information that I told you you needed, the kids, their dates of birth, where they go to school, where they've lived for the last 5 years, who's the most fit and proper parent, or if both parents are fit and proper parents to have custody, that would be in there. If it's one parent over the other, there would be a proposed parenting time schedule. If support is needed, that would be requested in there. If there's property to be divided, we just state there's property to be divided equitably, which means fairly. If we need any sort of restraining orders to make sure that no property is destroyed, borrowed, given away, sold, or transferred, we have to allege that that risk exists. If there's a risk that the marital home will be trashed, we have to put that in there and have an order entered that precludes any party from damaging any property. We also status quo orders. Again, that's something we contemplate in our initial filing. We file the complaint, a summons is generated. We then take the summons and the complaint and the financial form that I mentioned earlier, and a process server, or in some cases, it can be anyone who serves the person except for the party filing. So depending on preference, if they have an attorney, we'll call the attorney and we'll say, hey, we're filing, will you accept service? If they don't have an attorney, we may call them and say, hey, we're going to file. You probably don't want to be served at work. Do you want to come pick it up at our office? Do you want, to set up a meeting time and place? And we make it happen that way. Sometimes, it really just as long as the person gets served. After the person is served, they have 21 days to file an answer to the complaint. An answer is basically a pleading that says, I admit what you said in paragraph 1, I admit what you said in paragraph 2, I deny what you said in paragraph 3 because it's not true, things like that. And then they file an answer. Then what happens next is there will be, at the time that we filed, we'll also get an order from the court that requires the parties to appear at an early intervention conference, EIC. An early intervention conference is when you go to the front of the court and basically you have a discussion with the referee about the things that are at issue in your case, things that you're going to fight about. And they try to intervene to get things going as soon as possible. The EIC is usually scheduled within the first 4 weeks of the case being live. The other requirements that may happen pursuant to that first order generated by the court are the parties may be required to attend the SMILE program. The SMILE program is start making it livable for everyone. Is what it stands for. And it's basically talks about a little bit about the process, but more about the emotional drain and strain that is created by the process, how to help your children through the process, how to be supportive, and how to let people support you. The SMILE program is currently being done by video, not live. So it's eliminated the issue we used to run into where there was a PPO or a no contact order between the parties. They both had to go to the SMILE program. They had to make sure they didn't go at the same time. But now with video, we don't have that problem anymore. In addition, the parties can may also be referred to a program called COPE. COPE is a co-parenting program. Usually they're referrals for people who aren't married but have kids. But it's a really great program. Another thing that is recommended, not required, are parenting classes, and really learning about the developmental milestones of your children's emotional and physical well-being. And also if there are issues with your child's learning, or if they have any special needs, that's something that we want to make sure that their care is going to continue if there's anything happening that's being funded by the parents, not by insurance and not by the school. That's another thing that we need to deal with right off the bat. We never, ever, ever want kids to be compromised. So, as I said, the initial complaint and summons and filing fee, and a verified statement, which has a lot of personal information, the financial form, that's the initial filing. It spits it all back at us. We arrange for service for the other party of all those documents. If there's children involved, as a courtesy, we also include a friend of the court handbook, which is just a lot of answers to a lot of questions, which I think also generate a lot of questions, but it's a good first step resource. It is online. Depending on what county you live in, you just put in Wayne County Friend of the Court Handbook or Oakland County Friend of the Court Handbook. It will pop up and you can print it, or you can just look stuff up. It's helpful, definitely helpful. If you are dealing with parents who live in different states or are going to live in different states, I can tell you that the best long distance proposed parenting plan that I have ever seen is the one adopted by Lapeer County. And if you go on, if you just Google Lapeer County parenting time policy, you'll see it and you'll be like, oh my God, this is amazing, because it says that, if a parent happens to be in the state for more than 48 hours, this is what should happen. If they're here for less than 48 hours, this is what should happen. If the child is in their home state for any reason, this is what should happen. It talks about notice and changing of the schedule, and it's just really, really thorough. It's a great model. And so basically what happens next is that the answer will be filed, and then there'll be a status conference. And at the status conference, that will be kind of the first opportunity to say, like, hey, we're doing okay. We've exchanged. There's different ways to do discovery in a divorce case. We can do depositions, which are when someone is sworn at a conference room table, is how you've seen it on TV, to tell the truth, and they're asked questions by both sides. There's also something called interrogatories, which are just questions that the person is required to answer. There are rules in Michigan. We're limited to the number of questions we can ask in interrogatories, so that they're not unduly burdensome. They have to be relevant to the case. If you don't suspect that there's substance abuse, don't waste one of your 35 questions on substance abuse. So again, that can end up costing a lot of money if the discovery isn't based on appropriate facts, because they weren't disclosed at the initial meeting. I always tell my clients, I can't protect you from things I don't know. I can't strategize with things I don't know. So in my office, actually, we have a policy that you agree to be honest and you agree to tell me what I need to know. And even no matter how embarrassing or how small it is, you have to tell, because you don't ever want your attorney to be surprised. Even the most amazing, incredible attorney who can think on their feet like nobody's business still hates surprises. So with all of that in mind, certainly you will get through a status conference. A mediator may be chosen at that point. There also may be a request for psychological evaluations. There may be a request for the judge to speak to the children. There may be a referral to the friend of the court for custody or support evaluation. And that is an investigative procedure where all the parties are interviewed, documents are presented, collateral sources are considered, and a report would be generated with a recommendation for the judge as to how that issue should be decided. If either one of the parties doesn't agree with the recommendation, then they can object and they can have a hearing. And then finally, there will be a final conference, or sometimes called a settlement conference, depending on what jurisdiction you're in. And at that particular hearing, that's when the proofs are put on the record. If there's a settlement, the settlement can be put on the record, and that is the first opportunity to actually enter a judgment of divorce. In a divorce with children, there has to be 6 months between the filing of the complaint and the entry of the judgment, unless there are exceptional circumstances. Let's say that you're selling your house and it's going to lose value if you don't close before a certain date, and you can't close unless you have a judgment of divorce that tells them how to divide the assets. Then that's one of the reasons that the 6 months might be waived. There's some other ones as well. If it's a divorce without children, it can go from beginning to end, from complaint to judgment within 60 days. So what makes divorces longer or shorter is dependent on how much the parties are arguing about, and about how difficult it is to ascertain the assets or get the information. That is what delays these proceedings. What happens if people don't agree? We go to trial, and trial is not good for anyone. Trial is an airing of every bad thing that has ever happened between two people in most cases. Sometimes we go to trial just on one issue. It may be the value of the house. It may be support. It may be it may be child support. It may be how to divide the baseball cards. I've had that trial before, actually. I also sat in the back hallway of the courthouse with my co-counsel and divided them after all the testimony of how much each card was worth. So it's really not a good use of attorney time, but if we have to do it, we do it. So, other things that can happen during those initial stages are there might be motions that have to be filed. Let's say that a bill comes and you can't decide who's going to pay the bill because it wasn't a bill that existed prior to the filing, so it wasn't contemplated in the status quo order. You might have to file if you need to change your parenting time and the other parent won't agree. You might have to file a motion to get to change your parenting time. If one parent is withholding parenting time, that also might cause motions to be filed. If additional support is needed, that could cause motions to be filed. If out-of-state travel is contemplated and the other parent won't agree. Again, motions are separate hearings. They occur on specific days depending on what county you're in. In the Tri-County area here in Macomb, they're heard on Mondays. In Oakland, they're heard on Wednesdays. And in Wayne, they're heard on Friday. So, and if you want your hearing heard in front of a referee, your motion hearing heard in front of a referee, then it's on alternate days. It's either on a Tuesday or a Thursday. And that's a different scenario. So that's kind of the pre-trial, what it looks like, and what happens. I just got a question if a person wants to kick their spouse out, can they? The quick answer is no, not really. unless you're in a lot of danger or the home is at risk of being destroyed. And in that scenario, then you could. If your spouse is not on the lease or the mortgage, then you can absolutely go through eviction proceedings and get them out. But if they are on the lease or on the mortgage or on the deed and have some ownership interest, it's going to be very, very, very difficult to get them out short of abuse. I'm not saying go accuse your soon-to-be ex-spouse of abuse. I'm not telling you that at all, because that's a battle that costs a lot of money. And so that's kind of how it begins in an overview of what it is. I'm sure that there's more questions out there that I haven't answered, but I tried to hit the biggies. And of course, you can always email me your questions, lisa@kdlawgroup.com, or call me or send me a message through Facebook Messenger, whatever's easier, or just post it on the Facebook page. I often find that people ask me questions that more people than just that person are interested in the answer. So with that, 5 reasons not to harm your loved one while in quarantine. Again, number 1, protective services workers are essential. Number 2, the police are essential. Number 3, regardless of how safe they say they are, jails and prisons were not made for pandemics. They were not made for isolation of everyone there. They were not made for quarantine of everyone there. They don't have adequate medical care or disinfecting and sanitary methods available. And social distancing is really hard. So that's number 3, why you don't want to end up there. Number 4, parents can get in trouble for kids being kids. And 5th and final reason, very few people, if any, look good in horizontal stripes. And with that, I will say goodbye for now. Tune in tomorrow as we talk about kind of being on the flip side of the divorce, on the defense side, and we'll go into the best interest factors and what that really is and what they mean, and things to think about and try to ascertain about your own children before you have to argue about them. So with that, I hope you all are healthy and home and enjoying this beautiful day. And I'll see you tomorrow. Bye.